statement, really, I mean, amongst the whole issue with crime in this state. A lot of the concern that some of you have is not necessarily with the policing of youth crime, but rather with the way in which justice is dealt out. And regarding the fact that there's so much recidivist offending, many of you are wondering what's happening with our legal and justice system when it comes to youth crime. Why aren't magistrates and lawyers held more accountable for the fact that there is so much recidivist offending? We thought we'd put that to the president of the Queensland Law Society. In and amongst all this discussion around youth crime, Rebecca Fogarty joins us this afternoon to discuss what is and isn't working when it comes to our current justice system as we try to turn the tide on crime. Rebecca, thanks for your time.
Thank you so much for having me.
I've had people texting in today saying, why don't judges and magistrates have to answer for the fact that there is so much recidivist offending? Rebecca, from the Law Society's perspective, are we not going hard enough when it comes to sentencing?
Look, that's a question we get asked a lot, and it's genuinely a vexed question. You know, the job of the courts, the job of magistrates and judges is to deliver justice, and that means listening to what the prosecution says, hearing from the victim if the victim wants to tell the court about the impact of the offending upon them, and then learning about the circumstances of the defendant. And when a court hands down a sentence, it needs to do two things. It needs to do four things. It wants to hand down a sentence that will punish the person. It wants to hand down a sentence that will deter the person. It wants to hand down a sentence that will deter other people from doing the same thing. But it also wants to rehabilitate, because the safest thing for our community is to fashion a sentence that is going to promote rehabilitation. And that's 100% the case when it comes to kids.
And yet we have so much recidivist offending. So does that suggest that the rehabilitation isn't working?
Well, we have known for decades now. The research has told us for decades that the way to address youth crime, whether it's recidivist youth crime or not, is by focusing on the root causes. So we have decades of research that tells us this, that you need to address education, domestic violence, sexual abuse of children, poverty, homelessness, lack of education, lack of access to healthcare, and postcode disadvantage. We know that that's very clear, yet for some reason that has not been an attractive policy option for politicians. We know that what does not work is putting kids in jail. Now, that doesn't mean that children should not go to jail at all. No one would sensibly suggest that. Everyone is in agreement that when a child commits a very serious sentence and they're able to understand the difference between right and wrong, and they're able to understand what they have done wrong, they should go to custody. But that doesn't mean that custody should be imposed in all cases. The reality is, and research tells us this time and time again, as well as long experience, that when people sit in court, when they understand both sides of the story, very often they would hand down a sentence that is more lenient than what magistrates and judges have handed down.
So these are just everyday people sitting in a court. If they were the magistrate and they're asked what sentence would you give, they'd actually give less than what's handed down once they hear the whole story.
Once they hear the whole story, and part of the problem, I think, part of what is fueling this kind of divisive, politicised discourse that's happening in Queensland right now is that there's a lot of misinformation out there about sentencing, about the laws, and about the penalties that are given out in individual
Could you address
cases.
some of that? What's some of the information you've seen floating around that isn't accurate and that you'd like to address?
Well, the idea that criminals, the idea that magistrates and judges are a soft touch, the idea that they're not fully informed of all the relevant matters, the idea that they let young people off and don't understand what's going on in communities. None of that can be further from the truth. But the reason we have the justice system that we do is because if every victim of a crime was to prosecute someone who had wronged them, well, we understand that there's this high level of subjectivity, which means that perhaps they can't give a particularly just or non-subjective view of things. We have to have some objectivity in the system, otherwise an eye for an eye would be what happens, and no one would seriously suggest that that's appropriate for a modern contemporary justice system.
Hearing you from Queensland Law Society President Rebecca Fogarty. Rebecca, the LNP even today have made another announcement relating to what they will do if they get into power in the next state election. They say that young offenders would be judged on every police caution, restorative justice agreement and breach of supervised release order. And they say under that change of law, the youth offender's criminal history would also carry over into adulthood. Would that make judges or magistrates any more likely to give harsher penalties for youth offending?
Well, in every other domain of society, we treat children differently from adults. And I don't understand why, in the context of the criminal law, when we are dealing with the most damaged, the most vulnerable, and the members of our community who have been let down the most by our community, I don't understand why we are seeking to apply different standards. The whole idea of confidentiality behind youth justice proceedings is because it facilitates rehabilitation, because the vast majority of kids who come before the courts have made a stupid mistake. They grow out of it and they deserve a second chance. There are some people who are recidivist, but when you look at the statistics, the vast majority are kids who have made a mistake, like every single one of us have.
So is this are you concerned about the children's courts opening up to media? Is that what you're suggesting here, Rebecca?
No. But what I'm saying is that goes to the idea of criminal histories as well. You can have a situation where a person might have an entry on their juvenile criminal history, but some minor offence that they may have committed when they were 12 years old, how could that have any reasonable bearing on a totally unrelated offence that they may have committed when they were 35 in completely different circumstances? The thing is as well is that there is already scope for the prosecution to seek to put a juvenile criminal history before the court where it's relevant on application. And in addition to that, the Penalties and Sentences Act enables a court to inform itself in any way that it sees fit. So there's already that option. There's already provisions, but they come with safeguards to make sure that that other principle of justice, rehabilitation and reintegration, is not going to be compromised unnecessarily by base political agendas.